So now continuing to move up through our timeline, we have gone from the Whiskey Rebellion through the Civil War, through World War I and II, through the Cold War and the Korean and Vietnam Wars. And now we get to our sort of current age, which is the age of the War on Terror. And so as we've talked about, again, in connection with FISA and the Patriot Act and other things throughout this class, 9/11 changed everything, and it had a very significant impact on how we think about this backdrop of national security issues. I think you could see the kind of pendulum swing back and forth. At the time of the founding and at the time of the Revolutionary War, the pendulum was kind of swung toward limiting federal power and limiting the ability of the federal government to invoke an emergency, although it did exist. The Civil War, a kind of maximum of federal authority. Reconstruction and some of the disputes about Reconstruction, and after Reconstruction, maybe a little bit of a swing back toward the states. World War II, World War I and World War II, a swing back toward the government, and then maybe that expanding up through the Cold War, but then in the wake of the Vietnam War, a swing back a little bit the other way, maybe toward more accountability. And then, of course, 9/11, perhaps a swing back toward the expansion of the ability of the government, federal government, to kind of be involved. And maybe now, with some of the Edward Snowden revelations, some swing back or push back, although I think we're in a bit of a gray area right now. So I think it's interesting to see how those events affect how we understand these relationships under the Constitution and under the law. So, of course, one of the big developments after 9/11 was the creation of the Department of Homeland Security. And the Department of Homeland Security is created by the Homeland Security Act of 2002. The Homeland Security Act of 2002 is really the biggest reorganization of the federal national security apparatus since the National Security Act after World War II. So if you think of the kind of seismic event that World War II was in terms of the reorganization of legal and practical military and law enforcement authorities, another seismic shift after the Homeland Security Act. I also gave you a piece of the torture memo, the so-called torture memo, to read. And if you recall, this is a memo. It was an internal government memo laying out the ability of the U.S. government to use what some call torture and what others call active interrogation techniques on some of the suspected terror prisoners. And as you read that memo, and I really wanted to give it to you as, in my opinion, a kind of cautionary tale about the practical implications of thinking about the scope of presidential power and the scope of what a state of war or emergency allows the executive to do, and what the scope of a state of war or emergency allows the government to do in relation to what we might otherwise think of as human rights. And of course, as you read that memo, it's famous or infamous for arguing for a very wide scope of authority to use a wide variety of forced interrogation techniques. So this brings us to the discussion of Hamdi v. Rumsfeld. And Hamdi v. Rumsfeld is a constitutional challenge that reaches the Supreme Court to the detention of terror suspects at Guantanamo Bay. And those persons detained at Guantanamo Bay were being held without a criminal trial or any other kind of adversarial proceeding, and were being held without access to the writ of habeas corpus. And one of the key issues in the case is, well, we have here not just kind of ordinary criminal charges, but we have, the government claimed, we have enemy combatants who were taken prisoner during a time of war, and that the executive has the inherent authority under the president's war powers and specific authority under the Congressional Authorization for the Use of Military Force, or AUMF, that authorized the president to go after the terrorists who perpetrated the 9/11 attacks. So you can see the different opinions in this case, and it's very interesting to see the different justices and how it breaks out. In O'Connor's majority, she says the AUMF authorizes the detention, but not an indefinite detention. So at some point, there needs to be some kind of hearing. The hearing doesn't necessarily have to be a full-blown criminal trial, but it has to be some kind of hearing. But nevertheless, the AUMF did give the president the authority to detain these suspects. Now, Justice Scalia, who of course was the court's most famous originalist, writes a dissent, and interestingly joined by Justice Stevens, and Scalia and Stevens, of course, didn't usually agree on too much. But Scalia says that unless the suspension clause is invoked, a criminal trial in federal court would be required for these detainees. Justice Thomas, writing in dissent, now Thomas is also supposed to be an originalist, and so here again we see Scalia and Thomas disagreeing about what the original meaning of the Constitution is. But Thomas states that the executive has the inherent power in the time of war to detain indefinitely those who are designated as enemy combatants. So how does all of this relate to our subject of cybersecurity? Well, as we've been talking about all semester, the trend is toward the cyberification, if I can use a term like that, of warfare, of terrorism, of crime. And it's just a result of the fact that so much of our lives are done in and depend on cyberspace. And it's also part of the fact that cyberspace is really so vulnerable. And it relates back to the very first module in our series of these classes on internet governance, and the fact that it's tough to figure out how, if at all, the internet really is governed, and who, if at all, has responsibility and authority to secure it or to come up with rules relating to conflict in that space, and so on. So the U.S. federal government, of course, has thought about this long and hard. And early on, and this was a report that was done for President Obama a number of years ago now, on the risks of cybersecurity, and one of the conclusions of that report was these two words, which I think are kind of ominous words: regulate cyberspace. Regulate cyberspace. So really kind of strong, interesting statement that the United States has a economic and strategic national interest in asserting some kind of regulatory authority over cyberspace. And it raises this, difficult problem that we've been dealing with since the beginning of the Internet Governance module, which is, how do you safeguard critical infrastructure and vulnerable people while maintaining the internet as the unique open forum that it is? Now, in the Youngstown steel seizure case, there was kind of a paradigmatic example of where the executive sees an important national resource or facility that is being compromised in relation to a war effort or an emergency, and the executive wants to step in and take control of it. We saw the same thing, of course, during the Reconstruction era, with the federal troops literally stationed on the soil of the southern states in order to try and facilitate Reconstruction and protect the black citizens of the United States in the South. And we see that constant tension, and we see that reflected in the Posse Comitatus Act. We see it reflected in the National Emergencies Act, and so on. Well, within cyberspace, there has been an effort over the past 5 or 6 or 7 years to create some kind of national federal legislation that would require some specific kinds of regulation on the internet. And one of the main concerns of those proposed pieces of legislation was, well, what authority does the federal government have in the event of a serious attack or emergency? An attack that disables or damages a large part of the internet, or a cyber attack that threatens public safety, like an attack on the power grid or the water supply or something like that, that's facilitated by cyber means. And one of the early proposals was in a bill called the Cybersecurity Act of 2009, which did not pass, but it was a proposal that would have given the president the authority to declare a state of cybersecurity emergency and to order the limitation or shutdown of internet traffic. And this provision pretty quickly in the internet law community was dubbed the kill switch, the internet kill switch. Now, of course, I think it's impossible actually for anyone to implement a kill switch on the internet as a whole. It's just technologically probably not possible. But it certainly is possible to attempt to shut down or disable portions of it. We've seen this happen, and we see it happen repeatedly in other parts of the world where there are popular insurgencies against dictators. We saw it in Egypt against President Mubarak in what was at that time called the Facebook Revolution, because the organizers of the revolt against Mubarak used Facebook and other means of social media to help organize it. And Mubarak's government tried to shut down the internet. It's one of the very first things they tried to do. Now, of course, the situation in Egypt has developed in some really difficult ways, but nevertheless, I think the example of the fact that the internet is used to facilitate resistance to dictatorship, and that one of the first things that governments try to do to retain control is to shut down the internet. I think that's still true. So the kill switch was widely resisted, and this provision was not adopted. And in fact, we have not yet had comprehensive federal cybersecurity reform. A number of efforts were made after this 2009 effort to come up with some kind of comprehensive legislation, and they all sort of progressively watered down the ability, the express ability of the president or the federal government to declare an emergency or to shut down the internet. Although, very interestingly, the Obama administration continued to argue that the president already has inherent authority to shut down the network under the Communications Act of 1934. And it's a very kind of complicated argument. I've actually written a whole article about it if you're interested in it. But there is an argument to be made, I think a weak one, but an argument to be made that the Communications Act of 1934, which originally governed radio and telephones, could authorize the government to, at least in certain areas, take control of the communications network that we now call the internet. And this, I think, brings us back around to one of the basic legal and policy questions that I find most difficult and most interesting when we're talking about cybersecurity and national security, which is, where does cyberspace fit in to our traditional concept of the constitutional separation of powers? So we have here, of course, the executive, the White House, the Congress, and the judiciary, our traditional separation of powers. And of course, we would add onto that, not formally but informally, the sort of so-called fourth branch of the administrative state. But formally, of course, we have these three branches. And in particular, how does the check of the judicial branch work, and how does the check of the legislative branch work when we're dealing with cyberspace? What role does the judiciary have in approving and checking things like surveillance and search? does the existing framework under the FISA statute really create a meaningful judicial check? What role does the judicial and the legislative branch have in relation to the presidential power to declare a state of emergency, to possibly take control of the network or portions of the network, and or to engage in activities that might be considered acts of espionage or acts of war, like the Stuxnet virus? Does cyberspace create a new domain that is so new and so transcendent of national borders that we need to think in terms of a governance structure that goes beyond our framework of the nation state, and within the United States, our constitutional framework of the separation of powers? Or can our existing framework adapt sufficiently to deal with this? Lay on top of that history. Where are we in history now? Has the pendulum from the post 9/11 world begun to swing back a bit because of the Snowden revelations? Are we in a place now where we need to think again about some of these restraints, or not? Is public sentiment and is the necessity such that we need to continue to have the pendulum swing between these sort of areas of liberty and security towards security? Those are the big questions I'm going to leave you with, and that we're going to talk a bit more about in class tomorrow.